All right, welcome to the House Judiciary Committee this Thursday morning, May 14th. And we're going to get a preview of H937. It's the miscellaneous judiciary bill, and it's the proposed amendments that the Senate Judiciary put in. I also understand there is one additional amendment possibly that's going to be put in on the floor over there, but we can talk about that one, I suppose, when we actually get the bill. But we're just trying to set this up to understand where we're going to head with this, if we're going to potentially concur, or do we have further amendments, or do we want a committee of conference? But this is just a preview, and I will now turn it over to legislative counsel. Thank you very much for your patience. I'm assuming that you have been patient. Over to you, Michelle.
We learn patience on this job.
Oh, yes.
So it's essential skill.
Yeah.
So good morning, for the record, Michelle Childs, Office of Legislative Counsel, and we're going to take a look at draft 7.1 of the Committee on Judiciary amendment to H937. So this is on the calendar in the Senate for second reading. So it has not passed the body. So this is not this may be the final version, may not be. So I'm going to walk you through the individual instances. Hillary is joining me for this because there are a few sections that she was working on with members that then got put into this particular amendment. And so I'm going to turn it over to her. I'll kind of just identify what those sections are, and then I'll turn it over to her so she can discuss those with you. So looking at the first instance of amendment. So this is amending your version of section 2. And that is the underage possession of alcohol or cannabis statute. So that you guys did something to make it like an automatic reinstatement for those, if you recall. And then Willa Farrell contacted Senate Judiciary and asked for a further amendment in that section. And it relates to, if you look at the language in the amendment in subsection D. So you'll recall that, was it last year that you did the big youth substance abuse, that bill, right? And I think that this is just like another kind of oversight in that bill that just needs clarification from what I understand from the Attorney General's office. Is that, so you see the subsection D, that was added as part of that bill. And it talks about the DMV commissioner issuing a notice of violation and the suspension. So you recall that the way that it's structured is that the only offense that you get an automatic suspension of your driver's license is for the .02 and operating a motor vehicle, right? So that has an automatic suspension of the driver's license. The other ways you could wind up with .02 with a CDL. No, this is for the youth, or this is like right? So this section is just dealing with like under 21 alcohol and cannabis possession. So last year you added a new type of offense that could get referred to diversion, and they'd be eligible for the programming. And that was if you were under 21 and you had a .02 or over, right? And that would result in an automatic temporary suspension. There are other ways you could wind up with a temporary suspension, and that is if for the other offenses that are under that section, right? So possession of cannabis or alcohol, using a fake ID, that those offenses, if you did not contact the diversion board or you didn't successfully complete your contract with the diversion board, then you would wind up with a temporary suspension, okay? So one offense gets you automatic. The other offenses are only if you fail to successfully complete diversion. This subsection D, the way that it's written and the way that it refers back to subsection C, in that language on lines 9 through 11, it makes it sound as though it's confusing as to the suspension language around. It sounds as though they would be issuing it for any of the offenses. And it's intended to just be related to that .02 automatic suspension. Does that make sense to you? Is that I didn't staff that bill last year, but so just view that as a technical correction that was requested by the Attorney General's office. So the next instance of amendment, the second one, this deletes the House version's section regarding the establishing the minimum age of 12 in underage tobacco possession. And that is because you have S-198, which I think actually might be on the calendar today for debate on the House floor. I'd have to double check, but that is a larger, pardon?
Is it 198?
S-198?
Yes.
Yes. And so that is a larger kind of tobacco focused bill that was in Commerce and Human Services. And Human Services was looking at the underage tobacco provisions specifically because when that bill left the Senate mostly took out the penalties under that for anyone who's underage. I will admit I've been trying to keep an eye on this, but I don't know what finally came out is on the floor because I haven't read my calendar yet this morning. But because those issues were being dealt with by both bodies in S-198, we didn't want to have this particular provision around establishing the minimum age of 12, because oftentimes if you have two bills that are moving in the same session, we try to true them up if we can, or sometimes we have the ability if two bills pass amending the same section through statutory revision, we have the ability to kind of blend them together. However, because of the way that they're structured and they were restructuring some of that statute, it was going to be hard to kind of blend and marry them after passage. And so Senate made the decision, oh, you know what, this issue is being discussed. It's part of the dialogue. They know what the issue is, and we should just leave it to them.
Okay, but we don't know exactly what it says in S-198. I mean, we can.
Right.
We can find that.
I mean, but my understanding is they did consider it. The Attorney General's office and the court, I think, had shared this issue. I talked with Jen, who was staffing that issue in Human Services. So it was brought up. I don't know where they particularly landed on that issue. So if you are interested in doing something to that section, I would suggest you do it through S-198 and not here.
It is up today.
Right? So
Makes sense.
again, just to try to make sure we don't have a traffic jam at the end with conflicting language. So the third instance of amendment, and this fixes a typo in the section involving renewal of family division judgments. The word was affirmation, and it should have been affirmative.
What page you on, Michelle?
I'm looking at the amendment that Senate Judiciary passed. And if you're comparing that to what you passed, it's section 5 and subdivision B3C, which I don't know if you have the same version as I do, but my version is page 10 of the as passed by House version. And it says any affirmation action taken by an obligor, and it should just be any affirmative. So just a technical. Right, so now we're moving on to the fourth instance of amendment. And so this is where you have new sections that were not contained in your version, right? So the first new section is section 40A. And this section clarifies that victims can opt out of any notification or other services that DOC is required to provide to victims in various sections of Title 28. And this was something that was requested from the Victim Notification Task Force Group, and will allow DOC to offer a menu of notification options services for victims. And Hillary worked on this one. And so she's gonna, again, like I said, she'll follow up and talk to you a little bit more about these particular sections that I identified. Section 40B, this is the language from S-183, which was home and land improvement fraud that was vetoed because of the typo. And so this is just the substantive parts of S-183 without the typo.
So where was the typo when?
It's not in here.
It was vetoed because of a typo?
Yes, I caught it like right as soon as it passed, as I was doing it to review to send to the governor's office. And I checked in with the attorney general's office and I checked in with DSAS and I was like, it just was an incorrect cross-reference at the very end of the bill that was passed. And so I checked with DSAS and AGO. I was like, I don't think this is right. They agreed. We just missed it. I should have caught it. And so I emailed governor's counsel and advised her of that. But at the time, since we realized it immediately, Senate Judiciary had already decided to just fix the typo in miscellaneous. And I advised the governor's counsel that there was already a plan to fix the typo and it would so S-183 was supposed to take effect July 1st. I was just going to make the typo fix effective July 2nd, because you've been around here long enough, you know how we do that sometimes in these proposals. So advised the governor's office that it was already going to be taken care of and the governor vetoed it. And so we have to reenact the whole bill again.
That I've never seen done before.
Either.
So it's just, that was language that was changed in the bill that was going over and we just don't have that change.
Well, because of those reasons, yeah.
Yes, the language looks a little different because in the bill as passed, it has like the whole statute.
Yeah,
So
yeah.
if you read it in context, I just put the essential language in there, but it is exactly the essential language that was in S-183.
Absence the change that was.
Yes, because you don't actually, without that typo, you don't even need those subsections.
Got it. Okay.
Okay. So section 40C, this section clarifies that the liability caps applicable to federal section 1983 actions under existing law in the Vermont Tort Claims Act also apply to the new state cause of action created in 849, which is modeled after the federal law. This technical correction was based on conversations with the Attorney General's office that the clarification would be helpful in case of any ambiguity as to the General Assembly's intent. And that was Hillary's bill. And so she's going to follow up and talk to you more about that section. Sections 40D and E, these changes were brought to the attention of the committee by Vermont Legal Aid. So what they do is, section 40D amends Act 47 of 2023. So those of you who were here then may recall that the General Assembly created the Legal Aid's Tenant Representation Pilot Program. And the act included language that the program would begin only upon available funds. So you know what that language, that the contingency language that we're seeing often, we're going to enact this, but you're only going to do it if the funds are appropriated. The pilot project was supposed to be in 2 counties, Lamoille and Windsor counties. So the funds were not appropriated until FY25. And so the program actually didn't start until November 1st of 2024. And so what the language does in 40D and then 40E is it extends the program from just those 2 counties to they could offer those services statewide. And it also just adjusts the time periods for like reporting and things like that because it started later. So it's still a 2-year pilot project, but it's accounting for the later start date. And the language that you have in the 40E is just the monies that were initially appropriated are to carry forward.
So 40B, does that mean that this has to go to appropriations probably? It says money.
It did go to appropriations in the Senate.
It did go to appropriations.
Yes, it went.
So
Yes.
we'll have to go there from here as well.
For you to concur?
I will double check.
Okay.
So that one section might be.
I mean, like they'll probably weigh. You mean just that they'll weigh in?
Right. Yeah. They don't have to. Right.
So section 40 F and G, these sections authorize the Human Rights Commission to disclose investigative reports resulting from a complaint that's initiated by a commission employee as opposed to someone, a regular citizen on the outside. And Hillary has been working with the Senate on that. And so she can fill you in on those. Any questions about any of the ones that I went over?
Still 48 report.
H. Oh, I forgot. I just don't have my summary yet. 40H. So 40H. Yes, that is, and I'm trying to remember the bill number. You have a bill still on the wall. We took it up earlier in the session to, I don't remember, but it was related to abuse prevention orders, final abuse prevention orders. And you may recall there were two suggested changes that came from the network. It's Angela's,
28
Angela's bill. And the first change was, you'll recall that when they are making a determination whether or not to issue an order, right? The court has to first find that the defendant has abused the plaintiff, right? That's the first thing you have to find. Then the second one is, and that there's a danger of future abuse or the defendant is incarcerated, right? And so the first change in 628 was striking that the defendant is incarcerated and changing it to under the supervision of DOC. So in that case, and y'all talked about that a little bit ago at the time, it would be, so if somebody, and it's only certain types of offenses for which the person is under DOC. So like if you had an aggravated domestic, right? And so there's a final order going to be issued. Let's say the defendant does a split sentence and does 30 days, but then has the rest of the time on probation or some type of community-based service, is that the court could do the final order, even though they're not actually incarcerated, but they're serving their sentence in the community. And so that is this particular provision. There was a second provision in 628 that had to do with the ordering for the defendant to continue to pay household bills for which they were previously responsible. That is not in here. So this is just that first, change that was in 628. So I think the Senate Judiciary said they were open to that other piece, but it came at the very end, and they just felt like it needed more discussion and about it in order to feel comfortable with what language to put in there. And they did hear from the court.
Okay. Any questions from Michelle or any vote? All right, let's go to Hillary's sections for a deeper dive.
So we don't have possession of this.
Here's
bill?
what's in the city.
No, it's a preview. It's on action calendar.
I mean, while we're looking at it.
Yeah.
It would be just,
No, I said that. I said
You
that
did?
when we started. Yeah.
okay.
I made very clear
I
that it was.
apologize.
No, that's all right. Yeah. I made very clear it's just a preview and it's on action. So.
All right, for the record, Hillary Cheddar Ames, Office of Legislative Counsel. Of my three sections, the first is on page 2, as Michelle mentioned. This is starting on line 11, section 40A. This is the victim notification provision. So this, as Michelle mentioned, was a request from the Victim Notification Task Force group. Basically, Title 13 and Title 28 both contain provisions talking about victim notification. Title 13 is mostly about prosecutors having to notify victims. Title 28, in a bunch of different places, talks about DOC notifying victims. In Title 13, because it's all in one chapter, there's a really clear language saying all of these required notifications, victims can opt out, victims can waive. In Title 28, it's less clear because the victim notification requirements are kind of scattered, and it doesn't clearly say in all those places that victims can opt out. So the Victim Notification Task Force group said, we want it to be clear that DOC can offer kind of a menu of choices for victims to say, I want these notifications, but not these. And DOC's position was that for them to feel comfortable that they had that statutory authorization, they would like some clear language essentially saying, for any of our required notifications, victims can opt out. So that's the change that is made on page 2, lines 19 through 20. This is a section up front in Title 28 that kind of describes everything the commissioner is supposed to do. And it adds kind of that summary piece, a new 25, to say provide notification and other services to victims. But notwithstanding any of the other parts of Title 28 or even outside of 28 that require the department to provide notification, a victim may decline any notification or other service provided by the department.
So that section probably needs to be run by corrections and institutions, I think.
They have seen the they heard the proposed request from the task force group, and they have heard that this language was moving, and I think indicated their support for the concept. But yes.
So I mean, I'll go talk to Alice and see if she wants to have a drive-by in there or not. So, all right, okay. Any questions on that one? Anybody? Yeah.
Did DOC say that they felt like this language was clear enough?
Yes.
Great.
Their testimony in front of Senate Judiciary was that they liked it.
They liked it.
Yes.
Or if not liked it, thought it was sufficient for their
Great.
concerns. All right. The second is on page 4. This is section 40C, starting on line 13. And as Michelle mentioned, this is related to H 849 that has passed out of both bodies and passed into law without the governor's signature. And so this was based on conversations with the AG's office. The Vermont Tort Claims Act covers suits against state employees. So as you'll remember, H 849 envisions suits against local entities, state employees, or federal officials. And the Vermont Tort Claims Act essentially says you sue a state employee for torts or other violations, the state steps in to defend and indemnifies employees with some exceptions, but that's the basic idea. When it's a suit like Section 1983, so that federal civil rights statute that H 849 is based on, the Vermont Tort Claims Act also says there's a cap to liability. So this clarification is to make clear that just like H 849 is based on Section 1983 for interpretation of statute purposes, for how the Vermont Tort Claims Act treats these kinds of causes of action, it should also treat the H 849 action like it would one under Section 1983. So this specifies by adding on line 19 that where, I guess, lines 18 through 19, where the right of action is based on 42 USC Section 1983 or a similar state statute. So that would include something like the cause of action under H 849 or under a similar federal statute. The state shall indemnify the employee for the amount of the employee's liability. And then going on to the top of page 5, subsection B, these are those liability caps. So the maximum liability of the state under this section is $500,000 to any one person. And there's a maximum aggregate liability for each occurrence of $2 million to all persons. So this clarification just avoids any ambiguity in reading the parts of the statute together to clarify for H 849.
Yeah, go ahead.
Why not just reference the statute from H 849 instead of, say, similar state statute?
We considered multiple options. This was the one we went with. Both are options. So I think Senate Judiciary thought this worked. I think one possibility is, I guess, this might be the best way to capture kind of the way that you would read these statutes, even if this language weren't added.
Mm-hmm.
So the idea is you have a state statute that is supposed to be treated just like Section 1983, except it's state cause of action and it covers federal employees. So the way this is phrased just kind of further confirms, just like that language in 849 that says interpret this state cause of action just like you would 1983. Yeah. This is another way to say statutorily, like we are thinking of these things in the same manner. So this kind of similar state statute does that work, kind of confirming that language in H 849.
Do you think that it could open up the door for someone trying to push in another statute, arguing that it's similar to a 1983 claim? It's not the intended.
Interesting. I'm not aware of any other state statutes that create causes of action for constitutional violations.
Yeah.
So I think it would be hard. I think it'd be a pretty losing argument,
Yeah.
is my thought. And if in the future there were to be more statutes of that kind, I'm not sure what you could have that is like Section 1983 that isn't H 849.
Yeah.
So in some ways, I think it's a little bit of a closed universe, even though the language is expansive. But it's another way to kind of mirror the construction of this particular statute, where it's current law is 42 USC Section 1983 or under a similar federal statute. And so I think this is a way to both kind of stay consistent in the way this provision is constructed, and also, I think, kind of affirm the way H 849 constructs the cause of action, which is to say, just like Section 1983, but the state cause of action, and it covers federal employees.
No, that makes sense. Yeah, great.
Better answer than my first one. Got there.
All right.
All right, and then moving on to the third of my three sections. This starts on page 7. This is section 40F, starting on line 18. So Human Rights Commission, for anyone who has not recently been aware of everything that they do, they investigate and enforce state anti-discrimination and civil rights laws. So that includes fair housing, public accommodations, and public accommodations is pretty broad. So it can include hospitals, prisons, roads, schools, businesses, police, or other services. So this change is making a change to how Human Rights Commission essentially investigative records and decisions are treated. The baseline right now, what's confidential? Everything is confidential except the person being investigated can access the investigative file upon request, with a couple exceptions, but they can see kind of the case that's being put together, investigating them. And the Human Rights Commission's final determination, essentially the process is that Human Rights Commission staff investigates, they put together an investigative report that goes to the commission, which makes a kind of final determination and final decision of whether there are reasonable grounds to think that discrimination occurred. So under current law, if the commission's final determination finds that there are reasonable grounds to think discrimination occurred, then the final determination can be made public, which includes the identity of the person investigated. If the commission does not finds there are no reasonable grounds to think discrimination occurred, then they cannot release the final determination or identity of the person investigated. So that's current law. The other relevant piece to this change is that there are two ways to start Human Rights Commission investigations. One is any private person can file a complaint. The other way, and which the Human Rights Commission then evaluates, investigates, determines if there is a prima facie case to pursue an investigation. The second way is that a Human Rights Commission employee can file a complaint if they have grounds to think there's a prima facie case of discrimination. There was testimony in front of Senate Judiciary by the executive director of the commission that those employee-initiated complaints are generally for kind of broader impact kinds of issues. But I will defer to testimony forthcoming from the director from this committee to talk more about that. This change only pertains to complaints filed by a Human Rights Commission employee. So this doesn't cover any investigative materials related to complaints filed by private parties. Those are still treated the same way the current statute treats them, which is mostly keeping things confidential. But for a complaint that is initiated by a Human Rights Commission employee and that investigation, the complaint files and investigative files, just like under current law, stay confidential, except that the person being investigated can access the investigative or request some of the investigative file materials with some exceptions. But the change, this is page 8, starting on line 10, adding a new subdivision 3. There's a change for an investigative report. So as I mentioned, you start with a complaint, you have an investigative file, which is like everything that you collect in doing your investigation. And then the commission staff produces an investigative report, which summarizes, here's what we found in our investigation. Here's what we recommend, whether there are reasonable grounds to think discrimination occurred or not. and the commission then considers that for their final determination. This would make the investigative report in any investigation initiated by a Human Rights Commission employee not confidential, so it could be produced in response to a Public Records Act request only after the commission has issued a final determination and after the parties have been notified, with two exceptions, except that the commission shall not proactively disclose any report. So there was discussion in Senate Judiciary that they wanted the commission to be able to produce the investigative report in response to a Public Records Act request, but not proactively post it on their website. So that language says, yes, disclose it in response to a request, no, post it on your website. And the commission shall not disclose a few categories of information that are really carryovers from parts of the existing statute. So even though they can produce the investigative report, they shall not disclose and would have to redact the identities of any non-party witnesses to the investigation if good cause is shown to protect the witness's confidentiality, and information the release of which may be prohibited under state or federal law absent court order. So if it's otherwise supposed to be confidential under some statute, should still be redacted. Those two exceptions exist in the current statute for when a person being investigated asks for part of their investigative file. Those two kinds of information can be withheld. So it's consistent in that way with how the current statute treats those categories of information. The third category that the commission shall not disclose is the identity of the parties and any information that would identify the parties if the commission finds that there are no reasonable grounds to believe that discrimination occurred. So I mentioned earlier that under current law, when the commission makes a final determination, if they find there are reasonable grounds, then they can release the identity of the parties. But if the commission finds no reasonable grounds to think discrimination occurred, then the identity of the parties and any information that would identify the parties stays confidential. So this carries that over to the investigative report as well. So just like under current law, if the commission finds there are no reasonable grounds, then it can't disclose information that would identify the parties or the identity of the parties. And that will be true for the investigative report under this subdivision as well.
Are there any circumstances where, in the first instance, when they did investigate, there were findings, and they would release the report, but the victim, from a small state, does not want that released? Like, is there anything?
Interesting. So under current law, the Second Circuit has found it's not clear that the statute permits the commission to release investigative reports. The commission does not currently release investigative reports. I think the best first answer to your question is that this only covers complaints initiated by commission employees, which there was testimony that that's more systemic and it's not a private, it's not individual's investigative report.
Works at X. And their supervisor was right. Like
exactly. So I think in that case, that would be a non-party witness to the investigation, right? Like if they're not the party filing the complaint.
Right. They're the affected party, but they're not the party. Okay.
So I think if the non-party witness, if someone involved in the investigation, but not a party, thought their information should not become public, that they should maintain their anonymity because they still work somewhere or otherwise, then I think that is the if good cause is shown to protect the witness's confidentiality. I think the Human Rights Commission will be better positioned to speak to kind of how they handle this in investigations. But one concern generally is that to get people to talk to you, you often have to say, I'm not going to go out and tell everyone what you told me. And so I think there are kind of norms in place for why you would protect that information, but that'll be best place for that witness when you get there. All right. Running through. All right. The last change related to this issue is on page 10, section 40G. So because this makes a change, this is on passage. Without section 40G, it wouldn't be clear to the commission what to do with investigations that they currently have pending. right? So if a law passes, there are still things ongoing that it would apply to. Maybe the law applies, maybe not. It would certainly apply to any investigation that started after the law takes effect. But the language that Senate Judiciary chose was to specify that this change to how confidentiality records are handled should apply to any pending investigations by the Human Rights Commission. So if the Human Rights Commission has an investigation, again, initiated in a complaint by a Human Rights Commission employee at the time that the law takes effect, then they would be able to and would have to disclose the investigative report as provided in the section we just talked about.
Any other questions on those sections? Thank you very much. And so we will now hear from some witnesses. We'll kind of just walk down the road as we go, unless do folks have any time constraints? If I was going to start with Willa, then I would go to Willa, then Jennifer Pullman second, and then Bessie third, I think is my lineup. Well, I guess Todd is here as well. So
We'll be watching.
all right, thank you.
Yes.
Okay, will do. Thank you, Willa, for being here. If you could talk to us a little bit about the need for the first instance of amendment on page 1 of the bill.
Good morning. My name is Willa Farrell. I work at the Attorney General's Office with Court Diversion and Pretrial Services Programs. And the suggested change is to provide clarity. As Michelle explained, my understanding last year when the legislature added 0.02 violations, so people under the age of 21 who have a blood alcohol content of 0.02, that those individuals be offered the opportunity to go through the Youth Substance Awareness Safety Program, but that at the same time they would face an immediate suspension, similar to the civil process for adults. The way the language came out of Act 45, it sounded like all youth should be suspended immediately, and that was not my understanding of your intention. So the proposed addition is just to clarify that the notice of suspension is only given for the violation subdivision B1E, which are the 0.02 violations.
Any questions on that? Seems fairly straightforward. Oh, yeah, I'm sorry. No, go ahead.
Hi, Willa. I'm just wondering if you brought this up to the Senate and what
I
they,
only realized this, about, I don't know, it was after the bill had gone through your committee in the House. So I contacted the Senate Judiciary and Michelle Childs with the suggestion, and then Michelle explained it to Senate Judiciary.
and they didn't make the change for some reason?
Excuse me, no, they did make the change.
Yeah,
Oh, they did?
Yeah, this is all from the.
Oh,
Senate.
okay.
Yeah, this is
All right.
all their recommendations. Yeah. This is
That's not the first thing I've been confused on this morning, and I got an hour and 50 minutes left, so there may be more.
I'm with you. Any other questions for Willa? So thank you for being here, and thank you for being well. I'm assuming you were patient as we took a while, but
I
thank
was
you.
multitasking, so yes, thank you very much. I appreciate the opportunity to speak with you all.
All right, thank you. All right, so we'll go to Jennifer Pullman, I think, going to be commenting on, do I have that, on the fourth amendment, fourth?
Yes.
Yes, okay. Go, yes, thank you for being here. Nice to see you.
Oh, good morning. Nice to see you all. And I appreciate you being behind schedule because I was as well. So it saved me a lot of stress. So for the record, Jennifer Pullman, I am the executive director of the Vermont Center for Crime Victim Services, but also specifically for this testimony, want to note that I was the chair of the Victim Notification Task Force group that was established under Act 64. This late in the session, I still have hope, and I'm going to say this is a simple recommendation. It has been vetted through HCI, it's been vetted through Senate Judiciary, and it's a concept that has been brought forward to you. I'm going to speak obviously just on the fourth instant of amendment. And I don't think that this is a foreign concept for this committee, but just to give a little bit of context, we've been talking for a couple of years about the issues with victim notification. Most specifically, sort of post-conviction, but there are issues across the board. One of the pieces was that what currently exists in terms of notification is that there are many different notifications that DOC offers, but there's no option for victims to choose what they receive. There used to be that option, but now it's either all or nothing. And it was really important, and that was one of the things that we brought to this body a couple of years ago, that we get back to that model, because it doesn't work for every victim. It doesn't work for every survivor. There needs to be choice, restore some control, restore some agency. So that was a paramount goal of our group. It was actually established sort of in our charge as well. And what ended up happening was that as we worked on this, we identified a stumbling block wherein DOC was saying, well, we don't know that we can do this. I mean, they were working on it, but they were like, we don't know that we can do this because all of our obligations under Title 28 are definitive. There's no way that we can't not provide the notifications. So we looked at Title 13, specifically 5304B, wherein there's a statement that pertains to the services that state's attorneys, victim advocates provide, that allows for an opt-in or an opt-out. And what we wanted to recommend, and what Attorney Cheddar Ames perfectly captured, was that victims who are receiving or able to receive rights through Title 28 could have that. And that would then allow DOC to move forward with the menu, which, again, hearing from the field was really a paramount goal of our group. So this was a consensus recommendation. It was a group made up of state's attorneys and the Vermont State Police, DOC, the network, survivors. We had representation from disability rights, victim advocates as well. And it felt that this was an important starting place so that DOC could continue their work to develop a menu. I do want to mention, Chair Lalonde, you had noted about speaking with Chair Emmons, and I invite that conversation because she's been, her committee's been wonderful on this issue. We've testified a couple of times on this, and basically what she told Attorney Cheddar Ames and I was go chase it down in the Senate. She knows what the language is, and so in terms of that piece, I feel really confident that that will be a very quick conversation relative to the ones that you've been having lately. So just want to say that we've tried to button up all those pieces and think that this is a pretty much in the spirit of what the miscellaneous judiciary bill exists for. So thank you.
No, I appreciate that. So we'll talk to Chair Emmons, and thank you for laying the groundwork for all that as well. Any questions for Jennifer on this? Seems fairly straightforward, and we have been hearing about this for a while. So, so thank you very much. Appreciate it.
Thank you.
All right, let me see where we are next. So actually, we'll hear from Todd Daniels really quick because that's next on the list, and that hopefully will be short. I think it's please join us. Section 40C, the indemnification of employee.
Morning. Thank you for having me. Todd Delos, Assistant Attorney General. Hillary's description and explanation of this change is spot on. This is really, again, about ensuring that Act 87, H 849 fits into the existing tort claim structure in the state of Vermont. I think there is a strong argument that it fit under the existing language in 5202 of Title 12, which essentially says if you're suing an individual employee of the state, the action lies against the state of Vermont. That said, as Hillary pointed out, there is some language in 5606 that could be strengthened, and adding that simple, I think 3 or 4 words makes sense from our standpoint. And to answer your question, now, it was really, remember, it's not somebody who's acts that fall under the Tort Claims Act are really about limitation of damages, because this body, as the voice of the sovereign, gets to determine what the sovereign's liability is. That's what the tort claims limitations are. So that's essentially all we were doing, is making sure there wasn't potential unbounded liability.
Yeah. That's great. Any questions on that? Yeah.
I just have a background question, that we went over before, but if somebody is suing an employee and the state, the suit against the employee personally would be dismissed because is that right?
Yeah, I mean, it's a little more nuanced than that, but essentially the state will defend a state employee assuming the alleged acts aren't reckless
Okay.
or grossly negligent. There's language in it's also Title 3, 1101, I think, but I'm stretching my brain back to when I used to do this work. So yeah, the quick answer, yeah, 3 VSA 1101 defines an employee, and 5602 of Title 12 says when an act or omission of an employee of the state acting within the scope of their employment has caused damage, the exclusive right of action shall lie against the state of Vermont. And then there's that exception which says not if it's gross negligence or willfulness.
So if it's gross negligence, all bets are off and somebody can sue the employee.
The state won't defend them. Yeah.
Yes. And if there is a judgment, the state is not reimbursing the employee.
But I will say it's very rare.
I bet it is, but I just was kind of curious. And if there's a judgment and the employee was not reckless, the state foots the bill through insurance, most likely, or something. Whatever. It's the state
Self-insurance.
foots the bill. Okay. Thank you.
All right, any other questions?
It's 5 minutes. I did that. I left it at work.
All right, thank you.
Thank you all very much.
Yeah.
Thanks.
All right, so we'll go to Bessie Weiss next to join us. And this is on section
Start on this too.
40D, and it's on page 5 for both following.
Morning. For the record, I am Bessie Weiss. I am Special Assistant to the Executive Director of Vermont Legal Aid. And let's just formally interim Executive Director. Happily, we have a wonderful new ED. And yes, I am here regarding Section 40D to talk about our tenant representation pilot project. As Ledge Counsel Michelle Childs said, what this language change does is it simply allows us to expand the legal work that we're doing under the project to statewide, to other counties. It was in Act 47. It had been limited to Lamoille and Windsor. For a variety of reasons, we did not get as many cases from Lamoille and Windsor as we thought we would. One reason being the delayed appropriation that came to us happened in 2025. So the start of the pilot was delayed, and the start of the pilot unfortunately coincided with construction in the courthouses in both those counties. So at this point, we are simply making the change to be able to we have the capacity, the appropriation is enough to allow us to expand statewide, or at least in some other counties. we're ready and able to do that. And that would be allowing us to help more Vermonters until the pilot project comes to its end at the end of October.
Given that we have a landlord tenant bill that is moving through the body, should we be thinking about making sure that eligibility requirements are evergreen for any kind of change that comes from the changes in that bill? And I honestly don't really know where that's at in the Senate.
I don't think that's necessary because this was a separate act and a separate pilot project. And so I don't think that the passage, if the landlord tenant bill was to pass, I don't think it would influence this change.
The change as far as like the statewide, that makes sense. I just more meant like something that we're not actually talking about, but like the eligibility requirements for who would be eligible for the pilot program. Is anything that's happening in the landlord tenant bill?
I'm going to look at our ledge coordinator and
Policy director of Vermont Legal Aid.
has been closely following.
Right now, the landlord is under some significant changes.
Yeah.
And so I'm unsure if this would have. I think this is work we've been doing for the last year or so.
Yeah. Okay.
And we don't want this high tab bill at all.
Yeah. No, I more meant if something were to change from that, if it could.
Okay. Tell me.
And as Ledge Council said, the reporting changes align with the delay in the start. So they align with, the original act.
So there was
Later.
November 30th, 2025.
There, November 3rd, yes, there was a report, 1 month later. Yeah.
On line 13 on page 6 of this. Requiring a report for on the date that's already.
Yeah.
Any, I can ask Michelle about that. Any questions?
Just a similar.
Yeah, go ahead, yeah.
I have a similar question on line 9, page 7. I guess maybe it's just correcting when the program actually began,
I'm
but it's
assuming,
in the past.
yeah, I'm assuming,
So, yeah,
I'll ask.
just curious.
And this is at,
Yeah, page 7, line 6, it has.
Yeah,
Fiscal year
line 6
2025.
changes, right, and then line 9 changes it from July 1, 2023 to November 1, 2024. I'm wondering if that's just because that's when things actually started moving, and so it's just reflecting that. I would assume that's what it is.
yes, that's
Yes.
what I understand, yes.
Yeah, that's when we got the funds distributed.
Any other questions? So we have 2 witnesses more, we'll go with those witnesses and then we'll.
Thank you for having me.
Ben, if you can join us, we've been marching through, we get great overview from Legislative Council of section 40F. This starts at the bottom of page 7 and goes to page 10, I believe. You could. What you need for this, talk us through this a little bit.
Okay,
Thank you for being here.
thank you. Thank you so much for having me here. For the record, my name is Big Hartman. I use they, them pronouns. I'm the Executive Director and General Counsel at the State of Vermont Human Rights Commission. I am grateful to have an opportunity to speak with you here in the end times or whatever we're at. And I appreciate you taking time to hear from me today. So I am just here to talk about a very small section of your miscellaneous judiciary bill. And this is really an administrative change affecting a very small portion of our cases. As you all are aware, in the past 4 years, the legislature has really expanded our investigative and litigation capacity while also expanding the Vermont Fair Housing and Public Accommodations Act protections that we enforce. We take this expansion really seriously, and we are constantly evaluating
how we can use the tools and resources available to us to increase our impact in advancing full civil and human rights for all people in Vermont. So one of the tools that we have in our existing statute is the ability to initiate investigations as the agency rather than relying solely on a named complainant to provide a signed notarized complaint for us. And I think that this is a tool that has not been utilized very often, but we are starting to use it more and more as we have some capacity to do so. And we find it's appropriate to do these kinds of HRC initiated complaints. In other states, they call them director initiated complaints. When we're looking at like kind of a broad issue that could impact a class or a large group of people, or in instances where for one reason or another, a complainant may not be able to get a signed complaint to us, but it's something that's a significant enough issue that we want to investigate it. And this legislative change would really just impact the confidentiality of such an investigation. We are generally very restricted by our confidentiality provisions in section 4555 of Title IX. We are very restricted in what we can share with the public about our findings and the basis for them. And while parties do have access to our investigative file, they may do whatever they want with those. But in terms of what the HRC can make public, we're very limited. When we have an individual complainant who we're investigating discrimination for, they, like I said, can access the investigative file. They get a copy of our investigative report. And if they want to go tell the press about that or publicize that, they can do that. When there's no complainant, there's actually not a way that the public could be informed about the outcome of our investigation other than a determination, which is generally a very vague statement of like discrimination in housing based on disability, for example. It's not an in-depth review of the facts we considered and the legal analysis that we conducted. So this provision to add the language in section 4555A3 enables us to provide, in response to a public records request, we can provide the investigative report to a requester, which right now we feel there's some ambiguity about whether we would do it and we would not do it. I routinely receive requests for investigative reports and I do not produce them. And so it's not for all of our complaints. The vast majority of our complaints do involve individual complainants, but the very small number of complaints that the HRC feels it's worthwhile to initiate our own investigation on, there seems to be a gap in how accountable or public that the outcome of that investigation would be. It's pretty straightforward. Happy to answer any questions anyone has about that.
Okay,
Hi.
thank you for being here.
Thank you.
I'm wondering on page 8, line 15, 16, where it says identities of non-party witnesses shall not be disclosed if good cause is shown to protect the witness's confidentiality. I was just wondering like when and how that the opportunity to show that good cause would come up.
Well, we usually will hear from the witness when we are contacting somebody who's not a party to a complaint, is just providing some third-party testimony to us. They are often going to flag for us if they have concerns about their name being public. We may have for ourselves, in a high-profile case, for instance, another reason that we would think for ourselves, this is someone whose identity we can protect without compromising like the public's right to know. Yeah.
Okay, so it's something that you've already encountered in a sense over the course of regular business, and there are established practices.
Yeah, our rules do address this, and we use it sparingly. We typically will disclose, and this is the same kind of limitations we have in providing investigative files to parties, which we're authorized to do within these same exact limitations. And so we have had people who have provided testimony to us and expressed in the course of their testimony or in scheduling with our investigator, hey, I'm really scared that if I tell you my point of view of the situation, of the facts that I recall, that the person I'm accusing of doing wrong is going to come after me. They're going to like make my life miserable. They're going to try to retaliate against me. Is there a way that I can provide this to you anonymously? And we have mechanisms that we use to do that. And we, you know, the information they provide is still available to the parties, but their identity isn't. And sometimes we see that we need to shield a little more, because if you hear that recording, you're going to know exactly who that person is. So we're just always trying to be really thoughtful about that, but we haven't encountered that type of situation too often, thankfully.
Is there, are there any instances where there is both an investigation or complaint initiated pursuant to the like internal version that we're talking about, the 44554B, and also done like the other way by an outside party? Like, could there be two investigations going at the same time?
Generally, we discourage that.
Yeah.
And if we know that somebody has filed a complaint of the same things with another entity, we typically will not accept that for investigation, or we will dismiss it. Like if they file a lawsuit and we're in the middle of an investigation and they're alleging the same things that we're investigating, there's a concern about issue preclusion. And so our rules enable us to dismiss the complaint at that point in time with no prejudice to that party, but it just avoids having two conflicting findings of fact on the same claims.
Okay. Thank you so much.
Welcome. Thank you.
Last witness this morning.
Thanks, Greg.
Until we move on. At 11, we'll go back to 193. But Charlie, you could join us. You're going to comment on 40H, I believe.
Indeed. Good morning, Charlie Glesserman. I'm the policy director at the Vermont Network Against Domestic and Sexual Violence, and appreciate the opportunity to speak in support of Section 40H. This language would ensure that relief from abuse order access when defendants are under the Department of Corrections supervision is accessible to survivors. You may remember all the way back in February, we discussed similar language in this committee, but just wanted to provide a brief refresher and the opportunity to ask any questions. So this was an issue that was identified by attorneys working with survivors in the Vermont Network's Pro Bono Legal Clinic. As you know, RFAs, also known as domestic violence protection orders, are critical legal tools for survivors. They are civil court orders that protect a survivor or a plaintiff, and they request that order directly from the court to protect their safety. To obtain an RFA, a court must find that the defendant has abused the plaintiff and that there is either a danger of future abuse or that the defendant has been convicted of one of the serious offenses listed in the statute and is currently incarcerated. So examples of those offenses include domestic assault, murder, and L&L with a child. The miscellaneous bill would replace currently incarcerated with currently under the supervision of the Department of Corrections. So this proposed change would capture those who have committed those serious offenses and are incarcerated, as well as those who serve shorter periods of incarceration and subsequently live in the community on probation or parole. As a result of plea agreements, it's common for individuals to serve very short sentences or even no time incarcerated for domestic assault. So this revision would ensure that these victims can also avail themselves of civil protections. Even if a defendant is under DOC supervision, the risk of harm to a survivor, as well as the survivor's fear, can remain very real. In these situations, it may be more difficult for a survivor to meet the threshold of proving a danger of future abuse, even if the underlying conduct was severe and recent. It's important to update the statute to close this gap and ensure that RFAs are accessible to survivors who need them. And I appreciate your time and consideration. I would be happy to answer any questions.
It's fairly straightforward. We have probably had those questions last time on the other part of the bill, and that's not in here itself. Any questions for Charlie? Not. See, thank you very much.
Thank you very much.
So like I said before, it's kind of a preview. I do know that there is, I understand there might be a floor amendment related to changing the word expungible to sealable for the $200 bail limit. It's really correction, that's an oversight from last year's sealing bill, which we had in a bill that they didn't get to in the Senate, but it's pretty important that we clarify that. So I understand that the animal cruelty bill is on the calendar now. I'll probably do a preview again, just so we're ready on Tuesday. And I think we only need to hear from the legislative council and probably Lisa and my lot. I'm probably that's all we need to really to cover that ground. I understand the youthful offender proceedings bill H642 has changes that we may find issue with. And because we are trying on the House side, we're aiming for the 20th. I mean, that's optimistic, but that's just telling me that we don't have a lot of time for further amendment and sending it over to the Senate. There's a chance that we then lose that bill. So if we have amendments, so for that bill, more likely than not, we'll ask the committee to have a committee conference. I don't think that's going to be necessary for the animal cruelty bill, from what I just understand from the council has said that there's not like any huge significant things. And we're likely, if we get 193 out, which I'm planning to vote tomorrow morning after the floor, because there's going to be a token session on Monday. So whether we voted it out today or tomorrow, it would be on the floor on Tuesday. So I figured that would do that tomorrow. So I think that's it. So we'll just take if everybody could come back at 11 to see if we have invited some folks from Dale to weigh in on the latest 193. I don't know that we've gotten that confirmed yet, but we do have Katie McClin to do a walkthrough of the latest at 11:30. She's not available until 11:30, but just check in at 11 to see if we actually have witnesses then.